So we have two matters in front of us today, essentially two matters. One involves a motion to compel discovery, and the other involves a petition for order to show cause, as well as several replies back and forth.
And Your Honor, just for some housekeeping issues, if Your Honor wouldn't mind,
Sure.
At this time, in case F22-14137, the state is filing an amended information. The defendant is still charged with second-degree murder with a weapon. We're adding another count of interception of wire, oral, or electronic communications, a third-degree felony.
Can we see it? We've never
been notified of it. We've never seen it, which seems to be typical these days.
All right, nope, we're not going to have any of that here. If we're going to do any of the inappropriate comments or grandstanding, we're going to hold off on the hearing today.
Your Honor, while they look at that also, the state is also filing discovery for the court and handing over to defense a copy of the filing, as well as it's the warrants, Judge, that created the new case.
All right, Mr. Prieto, you did hear me just now, right?
Yeah, I did, Judge.
Okay, so we're going to keep it purely professional, and that includes everybody in the courtroom. So if it's not kept professional, then we're going to shut the hearing down today, and we will do it on another day when it can be professional. Okay?
Understood, Judge.
Thank you. So no throwaway comments.
Right.
You are in.
I'm sorry.
Judge, on behalf of Ms. Clenney, we're enter a plea not guilty, demand discovery, and request trial by jury.
Okay, thank you.
And Your Honor, with that being said, we do have an information for the new case. If we can address it at the very end, or we can do it right now. It's up to Your Honor.
You can go ahead and address it right now.
All right. So, in case F242015, the state is filing a consolidated information, consolidating F242016, F242169. It is making defendant A, Kim Dwayne Clenney, defendant B, Deborah Clenney, defendant C, Courtney Clenney. We're charging one count of offenses against computer users, third-degree felony, for all three defendants. We have provided a copy to defense.
On behalf of Ms. Courtney Clenney, we have not guilty demand discovery and act of the case we set aside.
Okay. And then for Ms. Deborah Clenney and Mr. Kim Clenney, who's representing them?
Your Honor, Kim Clenney and Deborah Clenney were arrested day before yesterday in Austin, Texas. They were subsequently released. They will be appearing in Miami at some point to self-surrender at TGK. There is a $5,000 bond, so those bonds will be paid, and they should be released, is the messages I'm receiving. But as of yet, we do not have counsel for them. Due to the nature and circumstances of what the state's allegations are, I don't think that myself or Ms. Puglisi can represent them. So we will get them counsel.
Does Your Honor want to set an arraignment date so that?
Well, I think that we need to set it for them to have attorneys and for us to make sure that they are represented. So I'm going to go ahead and set this as I would another case and set it for 2 weeks for court-rate attorney for them to come in with counsel. They don't have to be here as long as the counsel has filed a notice of appearance. That's fine. We'll do it the same as we would any other case. So 2 weeks for F24.
2015 A, B, and C.
A, B, and C?
Yeah.
216 for court-rate attorney.
And you want the C to travel along with them, Judge, even though it was arraignment?
An arraignment will be scheduled that same day.
Yes. All right. So then let's go back to Ms. Clenney's case. For the motion, we're going to start with a motion to compel discovery, because I think that that's going to be potentially more straightforward, but we shall see. All right, so this is the state's motion to compel reciprocal discovery based on some things that have been turned over, some things that have not been turned over. So let's discuss what you are seeking at this point.
Judge, the rules of discovery are clear that the defendants have an obligation to, just like the state does, to affirmatively provide discovery within 15 days. There are, among those witness lists, reports, statements that are made by those listed witnesses. Some discoveries since the state's initial filing, and December has been provided. We received a video that we were requesting for over 30 days. That video was removed, had audio removed. There's clear communications in the video. Those are statements of those people. We are entitled to that. The defense, for example, yesterday amended discovery listing witnesses. That's perfectly fine. I provided the court a copy via email. So again, they just have to provide a list 15 days upon these witnesses becoming witnesses, assuming. So that also is contingent with statements, contracts, agreements. It's anything that would be in theory discoverable. So for example, if they retained an expert, a point of contention might be this person's retainer. This person, you pay someone $1 million, they might say whatever you want. The state has not received any retainer agreements, any kind of contract.
Again, zero throwaway comments. Okay, I understand
Judge,
what you're
I'm sorry.
asking about discovery as far as experts, but
I was using an example, Judge, of a hyperbolic figure. My point is, and then that wasn't meant as a throwaway comment. It is a question of credibility what a witness might be paid, and the state is entitled to that discovery. To date, we have not received that. Similarly to the witnesses that were listed yesterday, the state did not receive any statements that might or might not have been made by these persons. Additionally, and pertinent to the collateral case, is Mr. Clenney was listed by both the state and the defense, and the communications in writing by Mr. Clenney with the defendant's counsel are all discovery needed to provide. So notwithstanding the fact that the state received some of those communications via a warrant to Ms. Deborah Clenney, those communications, all of them, are discovery to the state.
is that in your motion to compel?
No, Judge, the point is that some of this became sensitive investigative issues once it was discovered by the state in December. So some of the matters I just could not approach because, frankly, I referred it to Miami Police because I'm not an arresting authority and I'm not an investigator, I'm just a prosecutor. So some of these matters I just could not disclose or pursue because then it would hinder that investigation. So, but it's just a basic obligation under the rules. There's no obligation for a defense attorney to invoke discovery. If they do, then they have to comply with it.
All right, so what is it that you believe that is outstanding that you are specifically asking for at this time? I know that there were, it looks like the videos pertain to potential expert witnesses that I think at least one or two of whom have been listed. Yes, at some point the state is entitled to discovery regarding those expert witnesses if they've, drafted reports. They are entitled to the retainer agreement, but what is it that you believe at this point specifically that you are requesting that is in your motion to compel?
Yes, Judge. The state is requesting the names and addresses of all witnesses that the defendant has, quote, uncovered, because that's the words used by counsel. I'm not making a throwaway. That were present for any of these recordings, a list of the individuals that were present for the recordings that were made and provided. Specifically, there's several set of videos, but the studio video, for lack of a better term, one where there were 5 different takes, and there was a secondary video that looked to be outside. I don't know if that was only the defense's expert or other persons there recording it. Those people are pertinent for any discovery. The audio of the videos that were already provided. Anyone that was involved in the editing of those recordings as well. Particularly some videos were in slow motion. I don't know if that was a subsequent edit or anything else. That's obviously pertinent discovery. And then actually in the last line of our reply, I put statements and reports of any of the witnesses by the defense that exist in their care, custody, and control. And the state would just piggyback since they amended the discovery yesterday with some witnesses, whoever those witnesses are, if there are statements of those people.